Good morning. My name is Shyam Prasad, the Secretary in BCIC. I welcome all of you for today's very important webinar on understanding the Digital Personal Data Protection Act 2023, DPDP Act. It is my pleasure to welcome today's speakers, Mr. Supratim Chakraborty, partner Khaitan and Company, and Ms. Smita Jha, partner Khaitan and Company. I welcome today's moderator of the session, Mr. S. Sethuraman, Director Finance, Sasmos HET Technologies Limited. This webinar is organized under the aegis of Banking, Financial Services and FinTech Expert Committee. The committee chairman is CAK Vishwanath, Managing Partner, KP Rao and Company, Chartered Accountants. Co-chairman is Mr. Sudeep Srikanta Swami, Director, Wealth Management and Family Office, Bangalore, O3 Capital, and the mentor is Dr. L. Ravindran, MD and CEO, WealthMax Group of Companies. I thank BCIC annual sponsors, Bueller India, Continental, Fundamax, IMPL, MTR, SDMIMD, Sona Group, TVS, Vishwas Group of Companies, and Wipro. I request Mr. K. Vishwanath, Chairman of the committee, to make his opening remarks and set the context for today's webinar. Thank you, sir.
Yeah, good morning, everybody. And welcome everybody, all that who are present here on behalf of BCIC, all present here on behalf of BCIC Banking, Finance and FinTech Committee. And Murali, nice to have heard your voice in the morning there. And a special welcome to Supratim. Did I pronounce your name right? Supratim.
That's right, sir. Thank you.
Supratim Chakraborty, and then Smita, and nice to see Ramdas there. Thanks, Ramdas, for putting this together for us, and Mr. Sethuraman, of course, who's going to be moderating this session, and everybody else who logged in. Welcome. You see, this is the first program of our Banking, Finance and FinTech Committee for this year. And when we sort of talked about various subjects that we'd like to sort of speak about and introduce subjects to all of our members and everybody else who's interested in activities of the BCIC, Ramdas, our member, was very kind enough to say, to sort of offer to do this webinar on Digital Personal Data Protection Act. And we all know how important data protection is, and as we all know, it's the process of safeguarding important information from corruption, compromise, or loss. The importance of data protection increases as the amount of data created and stored continues to grow, and at very unprecedented rates, as we have all seen in the last 5 to 10 years. There's also little tolerance for downtime that can make it impossible to access important information. Consequently, a large part of data protection strategy is ensuring that data can be restored quickly after any corruption or loss, and protecting data from compromise and ensuring data privacy are other key components of data protection. We all know, of course, the coronavirus pandemic caused millions of employees to work from home, resulting in the need for remote data protection, and businesses must adapt to ensure that they're protecting data wherever employees are logging in from their residences across the country, across the geography, across the world. From a central data center in the office, it's moved to laptops at home. So therefore, what this webinar will do, of course, Sethuraman will tell you more about that, is possibly explore what data protection entails, the key strategies, trends, compliance requirements, and especially the data protection law. See, unless we have a law in respect of this, it's such a critically important aspect of all our lives that law is required to regulate this whole environment. So therefore, the importance of the Data Protection Act, and so therefore let's listen to the learned speakers. And thanks Prashant once again for putting this together for us. And welcome back. Welcome all of you once again. And let's go ahead. And I hand this over to Sethuraman, the moderator. Please go ahead, sir.
Thank you, sir. Now I request.
Thank you.
Now I request. Thank you, sir. I request Mr. Sethuram to introduce today's speakers, please.
Thank you. Thank you, BCIC, Shama Prasad. Thank you, Chairman. And echo thanks to Prashant Ramdas to put his hand up first, like Mr. Vishwanath was telling. Yeah. Now, yeah, Khaitan and company, we have two of their most young and learned legals in this protection. And I know Supratim, Mr. Supratim Chakraborty and Ms. Smita Ja, they have been working on this act and also advising into the government and also into MeitY for the past at least 5 years, if I can know. Am I right? Yeah, actually more than 5 years. Okay, and both of them are, as far as I go, one of the instrumental people in to whatever is their extent in framing this law. So I think it's good into BCIC, into the audiences also to lend a ear to them, or both the ears if you can, I would request. And Supratim Chakraborty and Smita have been with Khaitan, and I think they are the subject matter experts. As you all understand, I used to call it DP square. Okay, it's actually the DPDP is what everybody is coming out to. Okay, so it's a huge legislation, especially with all the countries grappling with it, the internet boom, the internet accessibility all across, especially into India, China, and then the inherent breaches of confidential and personal data, not in India, but for Indians abroad. All those are a big security, national security, personal security issues, which we are not aware of. Exploding financial payment transactions. Our India is at least 4 times to 5 times the other leading financial transaction country in the world, the China and the US. And it's a nice, in my opinion, a nice act that the Parliament realized to make it open discussions and also to legislate it with the basic protection to all the people concerned, that their own security is protected by law in the country and by other people also by the country. And I think to that extent, we should be, as common citizens, we should be having some comfort. Now, whatever is the next present, whatever is the next, the presentation may be for about an hour with followed by the question and answer sessions. And then I will keep mine short and leave it open to Supratim, who will open it along with Job for the next 45-50 minutes. Okay, I am not intervening. We will all mark Q&A towards the end, please. So it's always good to see that the smoothness in the presentation is maintained. So thank you so much and welcome once again, all the participants. Over to Supratim.
Thank you. Thank you so much, sir. Thank you, BCIC. Thank you, Chairman, sir. It's really an honor and privilege for us to be presenting before all of you. We will not waste much time. I'll straight away jump on to projecting our slide deck and starting off. Just let me know when you're able to see the screen and if it's in presentation mode.
Yeah.
Is that, yeah.
We can
okay,
see the
great.
screen. Yeah.
Great. I think like Sethuraman sir was saying, it has been a long journey. It's taken about 6 years, okay, for us to reach here. Now, let us talk a little bit about the history before we jump on to the law and the future of this law. So you all would be aware, Justice Sri Krishna Committee was formed in July, August 2017, and he went across the country to take stakeholder inputs, okay, including in Bangalore. So, our team members, including myself, we traveled across the entire country and attended every single consultation meet that he had conducted. And we also provided inputs to him, and he prepared a law. What the government felt at one point in time after that is that this law was becoming quite voluminous, cumbersome, and actually maybe something which they would call GDPR++, okay, a lot compliance heavy. So what was told was that probably we need a law which is less compliance heavy and easily understandable. So therefore, a leaner draft was thought of, and you saw towards the end of this journey, when the law was promulgated, it went pretty fast. Okay, on 3rd of August, the latest draft was tabled in the Parliament. 7th, it crossed the Lok Sabha. 9th, it crossed the Rajya Sabha, and on 11th of August, it was published in the official gazette after it received presidential assent. Now, mind you, this law, whilst the law is almost ready, the implementation related notifications are yet to come out. You would be aware last Wednesday there was a meeting of the ministry, the first Digital India dialogue in relation to the DPDP Act, and few important takeaways are there for the industry, and there we must talk about it right away. Firstly, the minister and the ministry folks made it very clear that the law would be brought into effect at the earliest. Okay, they would not give too much time. Really, someone talked about 18 months, etc. And the intent seemed to be really that not that much time may not be given. And there were some guidances which were provided. However, a few of them are like this: that the Data Protection Board, the adjudicating authority under this particular law, that would be brought into effect in about 30 days. We can expect maybe a little longer time than 30 days, but that is what was informed. Rule making has already started, and from now to about 30 to maximum maybe 45 or 60 days, you could see rules being rolled out in a staggered manner. Also, few other important things in relation to the rollout. One is that which entities will get longer time to comply. So what was mentioned is that government entities and state bodies and organs which are maybe lower on the digitization journey, they will get the longest time to really be compliant. Then you have the MSMEs and the early stage startups and some say entities like some of the hospitals, etc. They might be given a slightly longer time to be prepared because they are again a little low on the digitization journey, perhaps. But for rest of the ecosystem, rest of the organizations, the intent is to bring this into play at the earliest. Now, having said that, what was informed is if some particular organization or set of organizations believe that they would need a longer time to be compliant, then at the earliest, what was mentioned is, of course, 7 days odd, but you can sort of do it at the earliest. A representation should be made to the ministry, specifically stating the reason why a long time would be required and the exact time period that is fathomed to be the extended timeline. That is one. Now, there was also a discussion. This, if you see, is the distinction basis the type of organization. Now, the second distinction which was created during the meeting last Wednesday of the ministry is that the type of compliances that are there. Now, this law says verifiable parental consent must be undertaken if you are handling children's personal data. If you look at it, there is a lot of engineering, architectural changes will have to be carried out. So the ministry was open to take these on board and say, okay, if there are certain things which will take longer time because engineering changes, etc., would have to take place, we are happy to hear the industry. So why don't we have maybe a staggered manner of even rolling out the kind of things that are being talked about, compliances that are being talked about, okay? So therefore, if you look at it, there are two staggered rollout. One staggering is because of the type of entity that you are. Second is because of the type of compliances that are being talked about. For example, they say that, listen, normal notice and consent, will it make sense to really elongate the time because it's something which should be doable fairly easily? So just a hint of where we are headed and how things would go. With that, I will get details about this law. Firstly, we should know about some of the definitions. Okay, so some of the definitions are very critical. The first thing is personal data. Okay, the reason for this is that the entire law is revolving around personal data. Okay, this is also same for other international data protection laws like the European Union's General Data Protection Regulation, GDPR. So we have to be very careful when we are handling personal data. What is the definition? Fairly simple. Any data about an individual who is identifiable by or in relation to such data. Now, in your organization, mind you, this could be an inward looking exercise and an outward looking exercise. Inward looking, because your employee.
Yes.
Great. Sorry about that. So basically, if you see the first definition, it's personal data, and it says any data about an individual who's identifiable by or in relation to such data. So like I was mentioning, this could be an inward-looking exercise and outward-looking exercise. Inward-looking because your employees, consultants can come knocking at your door and say, listen, what data do you have about me? I want to change my data. I want to delete my data, etc. It is also an outward looking exercise because your customers, your vendors, etc., their personal data may also be with you. So the same thing could happen from an outward looking perspective. So you have to be careful at a 360-degree level. Then is the definition of data fiduciary or data controller as it is known in the international parlance. So what is this? Basically, it is any organization, any entity will be a data controller. Definition is fairly simple. Any person, which can be an entity, of course, also, who alone or in conjunction with other person determines the purpose and means of processing of personal data. Okay, so this purpose and means determining by the entity is very, very important. Let us take an example. In your organization, suppose you have deployed a payroll guy. Okay, you have a outsourced function of payroll. And you tell that, listen, first of every month, for these 1,000 employees, please pay these respective salaries. And that guy is simply following what you have told them to do. So in this classic scenario, you as an organization is the data fiduciary or data controller, as it is internationally called. You are determining the purpose and means of processing that personal data. That payroll guy, who's a data processor, the next line item, if you see, that guy is simply following your diktat and doing what you have told them to do. So the definition of data processor is any person who processes personal data on behalf of the data fiduciary. Okay. Now, an anecdotal story here, which I love to share. When Justice Sri Krishna was drafting this law, I asked him that, sir, why are you making life complicated? You can simply call these, data fiduciaries as data controller, as internationally they are known, and data principal as data subjects. So he said, Supratim, after the Britishers have gone, I would not like to call any of my fellow Indians as subjects. So that was on a lighter note. The real deeper legal meaning is he wanted to create a relationship of trust between the individual and the data controller, the organizations which are taking their data. Okay, so just keep that in mind as we are going along. Maybe this will be decided further in jurisprudence, in case laws, etc., by the Data Protection Board, by that appellate body, which is TDSAT, and maybe by the Supreme Court in future. Then comes data principal, which is the individual for whom this entire law has been drafted virtually. So what is the definition of data principal? The individual to whom the personal data relates and where such individual is, number one, a child. It includes the parents or lawful guardian of such a child. And number two, a person with disability includes her lawful guardian acting on her behalf. So this is data subject or data principal. Processing. What is data processing? It's a very wide and all-encompassing definition. Anything that you do with personal data will be covered. If you see, it includes storage of data, adaptation, recording, collection, organizing, everything. So even say the guy who's storing the data on your behalf, maybe in a cloud or whatever, all of this would be considered to be processing of data. Okay. So we move on. So what are the top 8 things that you need to know about this law? I hope my slide has changed right now.
Yes.
Okay, excellent. So now, firstly, remember that this covers digital personal data only. Okay. If something is written, some personal data is written on a piece of paper, it is not covered under this law. But if you scan that document and put it in your computer system or network, it comes within the fold of this law. The next is no non-personal data coverage. Okay, at one point in time, government also wanted to include non-personal data within the fold of this law, but thankfully, it was then thought that no, it should be kept aside. Third point is no categorization of personal data into sensitive personal data or critical personal data, normal personal data, etc. Now, this is also different from the present day law that we have in India, which is the Information Technology Act and the rules that are there on sensitive personal data. That is categorizing things like biometric information, health related information, payment related information, etc. as sensitive personal data, but this is creating a flat structure. Okay, so they are saying that, listen, if it is personal data, protect it uniformly. Now, this is a good and a bad thing, I would say. Good thing, because when we are setting off to sail, we need not look into our system and see where is personal data, where there is sensitive personal data, etc. Sometimes when we go to do these audits and due diligences on smaller organizations, maybe manufacturing companies also, and we ask people, are you handling any sensitive personal data? Often the answer is no, simple company, sir, we don't handle any sensitive data. And then we start looking into the system and we see there is biometric attendance at the gate. Then, HR would be having tons of sensitive, medical data because there is medical insurance which is involved. Then there is payroll related guys who are sitting on a lot of payments, bank account details, etc., etc. So unknowingly, if you see, our ecosystem is handling also a lot of sensitive data. So right now they're trying to create a flat structure, like all personal data, please handle it in an equivalent manner. Now, why this is maybe good to start with, but later on this could become a different situation is because of this. When you look at the penalty related provision, it can go up to 250 crore rupees or more. Why this could be, you can go up to the highest level through in what manner? There are certain parameters given, and the determining factor would be repetition of the breach. What was the mitigating actions that were taken? And then one of the line item is the sensitivity of the data that was breached. Now look at this very interesting scenario. When we started off sailing, we never differentiated between normal data and sensitive data. But as we went ahead and there is a bad day, there is a breach, then the determining of the highest degree of the penalty, one of the determining factor for that could be the sensitivity of the data breach. So thumb rule is we should still internally have a system that if it is sensitive data of some sort, like payments data or health related data, we should try and protect a little better. Okay. But as far as this law is concerned, it's a flat structure. Just remember that. Point number 4 is transfer of personal data to other jurisdictions. Now, at one point in time, we are all aware the government wanted to do a data localization. That was their thought process. Thankfully, there was a bit of a change in stance, and then they moved on to mirroring of data. And then finally, we have this situation where they are talking about that data can be transferred to any jurisdiction freely, no problem. But there are two catches. One is that there will be a negative list of jurisdictions which could be notified by the government. Once that happens, those jurisdictions could be embargoed as far as data transfers are concerned. And the second thing is that if there is a stricter law, then that will prevail over this general leeway. For example, Reserve Bank of India says that payment systems related data can never leave the country. Now that will still prevail over this general leeway which has been provided. Point number 5, which is no specific obligations are there under this law on data processor. So in my example of that payroll guy and your company, the payroll guy, against that guy, there is nothing specific written as an obligation. So you have to ensure as a data controller, as a company, that you have adequate contractual safeguard with that guy, and therefore that arrangement should be re-looked at. The agreements that you have with data processors, okay, a storage guy, data storage guy, or the person say who's giving you this payroll service, etc. See that is there adequate data related safeguards. Do you have indemnity cover? Do you need insurance to be taken by them? Do you need maybe a bank guarantee of sorts? So because the penalty amount is very high, 250 crore, right? You have to insulate your organization, and these are the mechanisms which you should devise and look at your contracts. This is a good time to start identifying such contracts. Point number 6 is enhanced obligations for handling of children's personal data. You are all aware in India, the age of child is pretty high. It is 18 years. Okay. In other jurisdictions like GDPR, it is 16 years. It can go below up to 13 years, depending on the member state of EU. So what do you do when you are handling children's personal data. They have said that there should be verifiable parental consent taken when you are handling children's personal data. Now, what is verifiable parental consent? That will be further delineated through rules which will come out. But there are also other things like, sorry, there's some noise. If you're not, you can just go on mute, please. Yeah. So if you see, there is also a bar on targeted advertisement, tracking, and monitoring of children. Okay. There is a possibility of lowering the age of consent from 18 years to a lower age, but that will be dependent on government being satisfied that the processing is being carried out in a verifiably safe manner. That's a minuscule exception. Do not rely right now too much on it till the exception is called out clearly. Expect if you're processing any data of a child who's of 18 years or below, you will have to follow all the requirements that I just mentioned. Point number 7 is personal data breach notification. Okay. Interestingly, unlike foreign jurisdictions, there is no materiality or risk-based threshold for notifying personal data. If you see GDPR, there are certain materiality-based thresholds which are given. Okay. And there are different types which are categorized depending on you have to make those reportings. In this case, it's a wide definition. Smita will take you through that. And once that happens, you'll have to mandatorily then go ahead and report to the Data Protection Board and also to the individuals who are affected. Okay. For the first time in a national legislation, data subject reporting is coming up in a very prominent and clear manner. Point number 8, very, very high financial penalties under this law. This is why it has become a board level discussion. Okay. And if you see, I will just show you the schedule of penalty. This is the entire schedule. The first line item is failure of data fiduciary to take reasonable security safeguards. Penalty could be up to 250 crore rupees. Second point is failure to notify Data Protection Board of India to, and affected data principles in case of personal data breach. Again, it can go up to 200 crore. So earlier there was this cap of 500 crore. And that got removed from the bill to the act stage. And people became very happy because they said, oh my God, 500 crore gone means 250 crore is the highest number that the penalty can be attracted in this law. The answer is wrong. If you look at it, you can, in a particular scenario, you can trigger one or more of these buckets. So it could be, theoretically speaking, 250 crore plus 200 crore plus 200 crore plus 150 plus 50. So that's the kind of penalty that we are looking at. And therefore, it's important that we start complying or thinking of compliance as the law moves ahead. Two important things, though. One is that there is no imprisonment provision. The government, you are aware, is kind of trying consciously to decriminalize a lot of laws. So there is no imprisonment provision. But the other important thing is maybe not very good from an individual perspective, but from organization perspective, there is no compensation provision under this law. So whatever gets collected actually goes to the government kitty, not a penny to the individual. This could avoid a lot of vested litigation, etc. Also remember that this law is a bit balanced law. Okay, there are certain duties for the individuals also, the data subjects or the data principals. If those are not followed, then there could be a penalty up to rupees 10,000 rupees. Now, the amount is low here for individual penalty, but at least there is something against the individual also. For example, they cannot give you false or fake information. They cannot start a frivolous grievance redressal process, etc. So all these things are very important because the law is here a two-way process. Okay, like the organization needs to behave themselves, the individuals also need to behave themselves. Okay, with that, I will move on to some of the aspects of this particular law, which is pertaining to, the first one is pertaining to applicability of the law, which is the first question that comes to our mind on what is this, this law applicable and whether it is applicable extraterritorially, etc. So to that, the answer is that the processing of personal data, when it is taking place within India, it is applicable when personal data is collected in digital form, or it is collected in non-digital form, but it is digitized subsequently. We had talked about it, that physical paper example that I gave. It is that situation here. Then we come to the extraterritorial applicability. And if you look at it, it is processing of personal data to an person outside India, if it's an entity of which is outside India, just providing goods or services to data principals to individuals within India, then this law will be attractive. Okay, there are certain exclusions from this law. One is personal data processed by individuals for personal or domestic purpose. For example, in your home tab or computer, you are making a list of people who will come to your birthday party. Okay, that is not included within this. That is for your personal or domestic purposes. Or what salary you give every month to your domestic helps. You are creating a list of that. That's your personal and domestic purpose. Then there are some other exceptions like personal data being made public by the data principal himself or herself. If you go and blog in some site and talk all about your personal data, then you expect that the law should protect it. That is not going to happen. Okay, so you have yourself put it out in the public domain. That goes outside the purview of this law. Point number 2, if there is an authority which is required to put out some personal information publicly because of a legal requirement, then also this goes outside the purview of this law. Next is a very important thing, notice and consent. I'll talk about. Be very careful as I'm taking you through this, because the minister has kind of alluded to last Wednesday that there are some simple requirements like changes to notice and consent. These are low-hanging fruits. There is no reason why industry should say that I need a lot of time to change my notice and consent-related documentation, etc. So request is, please start looking at the notices that you have and consent that you are taking, that language. So what does this law say? This law says that when if consent is a ground of processing, then you need to give a notice, privacy notice. And what should that notice contain? It should contain primarily 4 important things. One is, what is the personal data that is being collected? The purpose of collecting that information. Remember, purpose limitation is a very big thing in data protection laws. Why are we collecting? The purpose of collection, the manner of exercising right to withdraw of consent and right to grievance redressal. This right is there of the individual. You'll have to make them know about it. And then lastly, the manner of complaining to the data protection board. All these 4 things should be there. One interesting factor here is that the government wants that this notice and also the consent related documentation, the data subject or the individual should have the right to access this or option to access this in English or any language specified in the 8th schedule of the Constitution, which is like 22 languages. Now, this is quite cumbersome for most organizations. I tried to debate this with the ministry and told them that, listen, if it is a Bengali OTT app or a Tamil OTT app, which is trying to show you Bengali or Tamil movie, you tell them to put the notice and consent in those languages also, it's fine. But for every organization to do this in 22 languages, it is a bit cumbersome. But it seems like that government is pretty much keen to have this in play. And therefore, request is start thinking about those vendors or maybe tech solutions which can do the translation of your notice and consent documentation into those 22 languages. An important factor here is, and which question might come up, that what do I do with legacy data? Like in the present day situation, I might have already taken consent from people. And when I move on to the new regime, what do I do? So what this law is trying to tell is that per se, as per the present reading, is that is no re-consent required. But what you have to ensure is that a notice needs to go out as soon as this new law comes into play. So you can send blast emails, you can send in-app notifications to all your people from whom you have collected personal data. And the notice should contain all these 4 items that I talked about, which is in arrow marked here. Personal data being collected, purpose of collection, manner of exercising these rights, manner of complaining to the data protection board. Okay. So that is about notice. Now let's talk about another important pillar, which is consent. Remember, consent is still the mother of all grounds of processing that are there in India. So what does this law talk about in relation to consent? The top left-hand corner gives this in very, very clear manner. Consent should be specific, informed, unconditional, unambiguous, with clear affirmative action. So no pre-ticked boxes, no silence is consent. You have to have clear affirmative action by the individual and limited for specified purpose. Very interesting example has been given here. They're saying that there is a telemedicine app which is taking consent for processing your personal data for giving telemedicine services, and it is also taking consent for the entire phone book of your phone. that consent of the taking access to your entire phone book of a phone is no consent. So specified purpose will play a very important role. Tomorrow, the Data Protection Board may sit in judgment and decide that this kind of omnibus vague consent that you have taken is probably some part of it can be expunged, and that consent is no consent. So be very careful when you're drafting your consent language. It should have some semblance with the specified purpose of the business activity that we are talking about. The other thing which should go in that consent request is that the individual has a right to withdraw consent, and also this should be provided in English and other languages like I told you. You have to also give the contact details of data protection officer in case you are a significant data fiduciary. Now, what is a significant data fiduciary? There are two kinds of data controllers which are being thought of. One is a normal data controller or data fiduciary, and one is a significant data fiduciary, which can be depending on the kind of data, a lot of data crunching you're doing, sensitive data crunching, etc. Then that category could be considered as significant data fiduciaries. They have some additional compliance requirements. We'll talk about those. But the point is that if you are such a significant data fiduciary, you have to have a data protection officer in India. But even otherwise, if you're not a significant data fiduciary, you will have to have such an officer, and that person is supposed to respond to communications from data principals or data subjects as they are known normally for exercising their rights. Okay, so that's about consent. Now, with this, I will hand this over to Smita to take this forward for the remaining part, and then I will again come towards the end and come back.
Smita to unmute. Thank you.
Hi, sorry, just give me a second. I'm just trying to put up the presentation.
Yeah, we can see the screen.
No, I think
I think there's
Just
something
check.
wrong. Yeah, just.
Smita, if you're facing difficulty, I can control. Let me know.
Yeah, thanks, Shubhra. I think there's something wrong.
No problem. I'll just reshare and we can continue.
Yeah.
You will carry it with your 29.
Thanks, Shubhra. I'll just continue. So, just taking over from the entire consent infrastructure that Shubhra talked about, I'll be touching upon, this novel concept of consent manager and take you through the rights of data principal and some key concepts around significant data fiduciary. In terms of managing the entire consent infrastructure, while there are a lot of requirements in terms of how we fundamentally view the consent architecture, which so far has been quite, generic about our ability to take whatever personal data and process it in the manner that that data fiduciaries so far have been deeming fit. And the consent language, etc., used to be worded very, very widely in terms of what all could be done with the personal data of individuals. Now, obviously, there is a requirement of being very, very specific about the use and processing of that personal data. And in order to move to a compliant framework under this act, what the government has done is that they've also brought in this novel concept of consent manager. Now, the idea behind bringing this concept of consent manager is also, some of the learnings that the government of India has had in terms of looking at implementation of the GDPR, etc., where when EU countries really moved to the GDPR framework and adopting the consent infrastructure, there was a lot of requirement of taking fresh consents from their data subjects and all. And the entire effort kind of fell flat because there were very few responses from data subjects in terms of providing fresh consents and all. So in India, while we have not really gone into this whole concept of taking fresh consents and maintaining historic sort of grandfathered any sort of existing consents that have been obtained. We also understand that going forward, the ability to, take consents on an ongoing basis and basically hounding data principals with those consents may not really be very practical. And that is why this whole concept of a platform which kind of manages these consents on behalf of data fiduciaries and sort of maintains an interface with the user is something that's come up, and this is really something a matter of applaud. Just to explain the concept of what a consent manager is, we can possibly draw a comparison or a parallel with how we see the account aggregators working in the financial information space, where banks and financial institutions have the ability to register themselves with the account aggregators for sharing of financial information for which customers have already provided their consent. So consent manager is essentially going to be an entity or a person who's basically registered with the Data Protection Board, and their job is essentially going to be to manage an interface with the user who once provides its consent for processing of their information, personal information, and the purposes for which they provide their consent. It's expected to be an interoperable platform, and the registered data fiduciaries will then have the ability to process that information, and the consent manager is going to be a single point contact for that. This obviously makes the entire life and the implementation of the consent infrastructure very, very efficient. And we are genuinely looking forward to having the rules notified for this to get a deeper understanding of what are the rules and obligations going to be for the consent manager, and how do we go about engaging with these consent managers.
Hello.
One of the
Yes, ma'am.
Sorry, can I continue? I thought there was some interruption.
Can all
Yeah.
non-speakers mute, please? Thank you. Continue, please, Smita.
Okay, thank you. So yeah, consent managers, I think just for an understanding, we can draw a parallel with account aggregator framework right now. The difference being account aggregators currently deal with only financial information, and some of the personal information like KYC details, etc., have not been incorporated in that. But we are hoping that the framework gets extended, and it's possible that some of the account aggregators will also assume the role of consent managers. One of the things that we are not very clear on, that is this consent manager requirement going to be available at an individual level for each of the data fiduciaries, or is this something that's going to be entirely independent? Frankly, the rules are yet to come out, and we are yet to see how the infrastructure is going to be implemented. But this remains a concept which is very, very novel to India, with an exception of, I think, a couple of EU countries where the idea was initially designed and not really implemented. This part of the legislation stands out as very, very novel to India. We can, Shupra, we can move on to the next slide. Yeah. We also need to talk about, consent infrastructure is very, very important. And the whole idea is that we move to a very specific consent-based model for processing of data. But in all situations, this is, following the framework may not really be possible. And that's why the government has come up with the concept of legitimate uses, where once a personal data or information is provided to a data fiduciary, or to the government for that matter, even without specific consent, the fact that the act of giving of that data has been done by the data principal, it entitles the data fiduciary to use it for certain specified purposes, which includes things like data principal being in medical emergency or requiring healthcare services on immediate basis. In that situation, the entire framework of the 6 bullets need not be followed. The second requirement is, if at all the information is required to be taken in compliance with any form of judgment or any orders of the legal authorities, that's also something that you need not follow the consent infrastructure. Third aspect is for employment or safeguarding the employer from loss, liability, such as prevention of corporate espionage, maintenance of confidentiality of trade secrets, intellectual property, classified information, and things like that. In those situations also, the consent infrastructure is not required to be followed. And of course, the main rule is that if at all a data principal has provided consent voluntarily for specified purpose, then obviously that's the rule, and that also by itself is a legitimate use, unless it's for breach of law or not in compliance with law. So these are some of the legitimate uses that the government has specified, and these act as model sort of exceptions to following of the consent infrastructure. We can move on to the next slide, please. Yeah. Now, in terms of rights of data principal, the Act as such is a very, very, first principles based legislation. And there are further rules that are yet to be specified in terms of, some of the finer aspects of the regulations, whether in terms of obligations of data fiduciaries, how to go about, engaging with consent managers, and some of the other aspects. But in terms of rights of data principals and protecting their personal data, there are some of the key principles that have been highlighted, and we don't believe too many exceptions coming out to those. One of that is once the data has been provided to the data fiduciary, data principals still have the right to seek information about their personal data from the data fiduciaries, which includes getting the summary of their data, personal data that has been provided and being processed. They can also seek the details of the kind of processing that is being done to their personal data. A related point is also getting identities of all the data fiduciaries and data processors who have access to that personal data. And the third part is a catch-all, which means that any other information which relates to their personal data and its processing is something that data principals have the right to seek from data fiduciaries. We believe that once the consent manager infrastructure is put into place, these rights are some things that will also extend to the consent managers, and they will be under obligation to provide all of this information to data principals. The second and very, very important aspect of this legislation is a grievance redressal mechanism. So every data fiduciary is required to have a grievance redressal process, and data principals' first port of call is going to be the grievance redressal process that has been set up by the data fiduciary. Any form of appeal against the grievance redressal forum set up by data fiduciary is going to go to the Data Protection Board. Important thing to note here is that data principals cannot directly go to the data protection board. And the idea is to exhaust the mechanism or the right that they have against the data fiduciary, because it's a tired approach that has been followed in the Act. We'll go over that once we talk about the grievance redressal. We can move to the next one, please. The third right, which is very, very important for data principal, is a right to nominate any other individual who can exercise their rights. This is something that is available in the event of death or incapacity of data principals. So essentially, even a deceased person's data gets protected, and their nominees do have a right to ensure that their that any personal data of a deceased person is also utilized in the manner which is prescribed in the Act, and all of that information is still a subject matter of protection under the Act. And the fourth and one of the most critical rights which are available is basically a right of correction and erasure of personal data. So any sort of inaccuracy or incompleteness of data is a matter of right for data principal to have it corrected, and they can reach out to their data fiduciaries or consent managers and have their information corrected. One of the important aspects is also erasure of personal data. Not just erasure, but also ease of that erasure of personal data is something that the Act has harped upon. So it's not good enough for the data fiduciary to provide an avenue to the data principal that, hey, you can come to us and seek a deletion of your data. But the way the entire consent infrastructure needs to be very, very user-friendly. The right to seek an erasure of that information is also something that needs to be extremely user-friendly. The only situation in which even after a request for erasure of personal data that can be retained is basically a situation where the law requires the data fiduciary to keep that information. And one of the examples would be, if you're a bank or a financial institution or a reporting entity under the PMLA, the law requires you that you retain that KYC related data for 5 years. And in that situation, I, as a customer of the bank or that reporting entity, cannot say that, hey, delete my personal data, because that the law mandates that these financial institutions retain it. So, a very, very limited exception, again, right to seeking deletion of personal data. But yeah, I mean, that's the only thing which is available for data fiduciaries to take refuge in. We could move on to the next slide, please. Yeah, now in terms of, what exactly is the obligation of a data fiduciary? The idea, of course, is that, to the extent you're a repository of personal data of data principals, you need to protect it. But what happens, what is the meaning of that protection? That, there's a concept of data breach under the Act, which basically is defined as any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, loss of access to personal data that compromises the confidentiality, integrity, availability of personal data. So, I mean, the way to read in terms of what would constitute a data breach is basically any sort of unauthorized processing. We know that definition of processing itself is wide enough to include its use, it being analyzed for various purposes, it being transferred or shared with any other third party, or it being utilized for any sort of cross-selling, etc. And of course, there is an obligation to maintain confidentiality and to not allow any sort of transfer or use for which the user has not authorized. So the way to read data breach is basically you look at the obligations of the data fiduciary, and anything which is not authorized by the law is basically a data breach. And the first and foremost obligation is that the data fiduciaries maintain enough of security standards, which are basically technical security standards and policy standards as well, to ensure that there is no unauthorized use or processing of this data which is being done. We already talked about the penalties and also security breaches would basically, result in a penalty which may extend up to 250 crores, which is a huge amount and the stakes are really high. The second requirement under the law is that the moment you become, as a data fiduciary, you become aware of a data breach, please notify it to the Data Protection Board. And like Supratim was talking about, that there is a tiered approach to how penalties would be imposed. These are some of the measures that will really be accounted for in your favor or against, depending on how you react to it. So the idea is that, you have processes inbuilt which provide for mechanisms on immediate basis in terms of relevant information to the Data Protection Board. And like Supratim mentioned, there are no materiality or risk-based thresholds for notification. In fact, if you do not notify, the penalty for that itself is 200 crores, which is pretty high. So the idea should be that, firstly, we are looking to be entirely compliant. And if at all there are some breaches, even unintentional ones, there are enough adequate processes and responsible people to make a notification to the Data Protection Board. And all of these efforts and mitigating measures will go a long way in ensuring that, we try to minimize the penalties on that. We could move to the next point, please. We now come to the concept of significant data fiduciaries. Like we talked about at the beginning of the presentation, the approach is two-tiered. We have data fiduciaries, who are basically the entities or people who determine the purpose and means of processing of that data. And within that, there is going to be a subset of significant data fiduciaries who are data controllers, who will be imposed with higher data obligations. Now, how exactly is the government going to determine in terms of who constitutes a significant data fiduciary? This is also a rule-based approach that has been taken, but the expectation is that, there will be a few factors which will go into determining that, and we'll just take you through some of the things that I think there's some questions on this. We'll try to address it at the end of the presentation. Hope that's fine. Sorry, could we just go back to the previous slide, Shupro? Yeah, so, quickly, a few points. Volume and sensitivity of the personal data, that's going to be important, and how much of that is being processed by a particular entity. Risk to the rights of data principle, a risk-based approach. Like if I'm an entity who processes some personal data, but that's really harmless, probably they will not constitute significant data fiduciaries. Potential impact on sovereignty and integrity of India, which is generally a key constituent in such determinations. Risk to electoral democracy. This is again a policy side of the risk. Security of the state and public order. So these are some of the issues which are actually coming from GDPR and some of the recent examples of how the electoral democracy in the US, etc., was affected by the things that Cambridge Analytica did, the role of Russian influence in US elections, etc. So, some of these things are important, and these are the things which are going to determine what a significant data fiduciary is going to be. We can just move on to the next slide. Yeah. In terms of, if at all you get notified as a significant data fiduciary, what are the existing additional obligations that you have? You need to have a data protection officer who's based in India. and who will be the single point of contact for grievance redressal. There needs to be an independent data auditor as well, who will evaluate compliance of significant data fiduciary. And the third and another important obligation is data protection impact assessment that needs to be carried out. These are basically periodic audits which need to be carried out by significant data fiduciaries. Besides this, there's a possibility that once the rules are notified, there are additional obligations. But like we mentioned, this is a first principles legislation, and the devil is going to be in the details. So we'll have to wait it and watch out for the rules to understand what are the additional obligations. We can quickly go over the grievance redressal mechanism. It's basically a tiered approach to grievance redressal. The first level is the data fiduciary level itself, where they need to have a mechanism. And as a principle, if my rights are affected, I need to be in a position to contact the data fiduciary. Like I mentioned, we will need to see this, how exactly does it tie up with the consent manager concept, and how it, will the grievance redressal facility be available through the consent manager, or is this something, we'll have to figure out how to go about it in terms of with the interplay with the data fiduciary. Second is appeals from the grievance redressal. If there is a dissatisfaction in terms of how my complaint was addressed, I do have the ability to go to the Data Protection Board. Further appeals from Data Protection Board will lie with the TD-SAT, and from the TD-SAT, it can go to Supreme Court. So the Act itself does not really provide for a compensation-based approach, but we will have to, probably rely on judicial pronouncements to see how the judiciary and is viewing those kind of claims under the Act. I will move this back to Supratim in terms of he's been closer to the policy making and been involved with the ministry. And, Supra, over to you in terms of, talking through the points around implementation and some of the important measures that need to be taken by fiduciaries.
Right. Thank you, Smita. So this has been the journey till now. I think there are certain low-hanging fruits which you can start looking into, as I was talking about right at the beginning. And also the minister alluded to this, that let's see, when we talk about normal notice and consent related changes, if you ask that you need 18 months, I'm not going to digest that, right? So it's very clear. I think we should start moving very quickly on this. So start looking into aspects such as notice, recrafting of the notice the way we discussed. And maybe once the rules come in, you actually can dot the I's and cross the T's. Also, the mechanism of withdrawing, of giving consent and withdrawal of consent. Evidence of consent and notice. In a bad day, you as an organization will have to prove that notice was given and consent was taken. We talked a lot about consent in relation to children's personal data, where you have to take verifiable parental consent. That also you can start looking at. There could be some eKYC for parents, which could be devised. And this could come in a little later as compared to other compliances. So maybe you can keep an eye for that rule when it is coming out. Next is translation for notice and consent. Again, start looking for maybe vendors or tech solutions which can help you with these translations into 22 Indian languages. Then comes appointment of a person who could be data protection officer in case of a significant data fiduciary, or even otherwise. Any organization would need a similar person, whether branded as DPO or not is a different story, but you need someone at that position. Start identifying that person. Okay, who could be that person? Next is data principles, right? We talked about it, whether it is your employee or your customer, they can come knocking at your door and say, listen, I want to understand what data do you have about me? I want to exercise my right of correction, erasure. So that process, you'll have to start gearing up from now by doing data mapping exercises, etc. So now the last one is contracts with data control between controller and processor. Okay, whichever side of the fence you are, either you are a data controller or a data processor, start looking into the contracts very carefully. You have to insulate yourselves completely because like we discussed, the exposure is largely monetary exposure. Okay. what are the things that we are doing to assist our clients, and how you can also sort of devise this as a plan in your organization. There are 3 stages largely. Okay, stage 1 or phase 1 of this program should be training and sensitization. But remember, one size does not fit all. So it is again a tiered approach. The first one could be a 45 minutes to 1 hour presentation to the board or the leadership. The second could be 1 to 2 hour training session for the mid management, and maybe a half a day or a full day masterclass for the individuals who would be dotting the I's and crossing the T's in your system, like legal team, compliance team, privacy team, etc. Moving on, the second phase of this program is gap analysis. Okay, and this you can start doing as soon as the rules come out, because then you'll know exact changes to be brought about. But start identifying these avenues right now. Okay, and you can have privacy champions within your business, departments that you have, because otherwise this is a little difficult to roll out as a program. Privacy as a program within the organization. What do you do in the gap analysis space? You interview the relevant stakeholders. We are preparing questionnaires, which is curated after the discussion that has happened with the relevant stakeholders, and then start the gap analysis and do a report out of it. Where do I stand today and where I have to reach? Third phase is implementation or effecting the recommendations that come out of the gap analysis report. For that, you need discussions on the implementation, a step plan for the rolling out of that recommendations, and then finally assistance with the implementation wherever required, like privacy notice drafting or recrafting, consent requests, agreement related clause banks, etc., etc. So that's about it from our side. I will stop sharing and back to you, sir. Sethuraman, sir.
Thank you. Thank you, Supratim and Smita. Yeah, can you hear me?
Yes, sir.
Yes.
Okay. So there are a couple of questions which is there. We'll tackle that first. One of it is right now when you were doing the presentation, can you very briefly specify obligations for non-IT companies, like requirements related to payroll? That is from Bindu Madhav, but I think I don't have any relation or something like an IT or a non-IT in the act. But I know the question is all our heart. So I also sympathize with Bindu Madhav. So can you have some say on it? Can you see that? Yeah.
Yeah, absolutely. So a very good question. And I think majority of the organizations are kind of thinking about this question, especially in the manufacturing space. If you look at your ecosystem, you would be maybe very light on customers' personal data, but very heavy on employees' personal data. In the employer-employee segment, firstly, the notice and consent, etc., are very critical. Okay. You have certain avenues for deemed consent. For example, if you are doing an employee investigation, internal employee investigation, you need not take consent. All that good things have come into the law. But otherwise, right from the stage of identifying a person as a prospective employee and taking consent from them, to the keeping of their data and expunging it maybe at the end of the person leaving after whatever X number of years. This is an avenue that you need to think through clearly, that what is the journey of an employee through your organization. In between, there could be mergers and acquisitions which are taking place. So data of A company is moving to B company. Do I have consent for that also? Because in a commercial sense, in a commercial M&A, technically speaking, you have to go to the last employee and say that, listen, we are moving you to entity B, please give me your consent. So it is a wise idea today to take a relook at your employment letters, handbooks, IT policies, etc., where all clear consent is required to be taken. Okay, we have again that avenue for deemed consent, but use it sparingly, because remember, till now, India as a country is largely depending on consent. Okay, so our judicial bodies, etc., are more adept to understanding clear consents. The moment I say that I'm taking deemed consent, it could sort of be a little difficult for judicial bodies to fathom that. We can use it sparingly in case of, again, internal employee investigation, etc. But for all other purposes, for now, have robust notice and consent mechanism. That would be my first and the most critical advice to you.
Are there any requirements for registration under the DPDP Act?
No, so very good question again. The Data Protection Board, the minister has also clarified, it is supposed to be largely an adjudicatory body. It is not supposed to ordinarily, see, registration is there for, say, player says the consent manager. But otherwise, they are very clear that, listen, I don't want to take regular audit reports from you, etc. We are not getting into that domain at all. We don't want to also create a parallel police mechanism. Okay. It's a very fairly simple board which will adjudicate largely. Okay. So please look at it from that lens.
Pushpa has a question. She is from an active NGO, and they have problems when it comes to CSR notifications and laws, and where they do a lot of educational activities into children, and on certain things. I understand the government also gives them some funding. They have to report the CSR completion as per the act and all that. And on this basis, how are we planning to handle the children specific data and consent? Do they have to go to the parents now, which they may not have? Would you throw some light on that?
Yeah, so this is a very special avenue, and I would request that once the rules start coming out, there is an avenue to seek exemption. Okay, so we articulate this better and present it to the ministry regarding the exemption that we are really seeking, because it's a practical difficulty, B, it's an interplay with other laws also. Okay, so all of this taken together, if we make a cogent case, we have seen in the recent past that some of these very cogent articulation of real problems, the ministry has been very receptive to. So let us, for example, this verifiable parental consent for children's personal data handling. We recently, last Wednesday, when we were having the discussion with the ministry and the minister, he was very receptive to the fact that, listen, when we have to do this, there will be a lot of engineering changes which we have to do in your system. So I cannot expect that all organizations will do it readily within no time. We will give you more time for those things. Okay. So we have to make a case. My request is that we present it to the ministry in articulating it in an appropriate manner. It should be, I think, heard.
There is another current question. So I will raise, and then in case a firm is sharing personal information with third parties at different levels, for analysis purposes, will such third party fall in the shoes of a data fiduciary, or will it remain a data processor?
I think the thumb rule we have spoken about right at the beginning, who is determining the purpose and means of processing personal data? Okay. There could be situations where there are people who are joint data fiduciaries or joint data controllers. Okay. Be very careful to analyze when you're giving the data and telling them that just listen, you have to analyze this and give it back to me. Do not apply your head on purpose and means. Then that other guy is a processor. But the moment that guy is also applying certain means on the purpose and means front, there could be a situation where both of you are becoming joint data processors, controllers.
Okay. Now, I have a question. Globally, how is India placed? See, we know a lot of talk on the DPDP, but it is suddenly, and it is massive. When I look at it, you have to go to the 125 crore people, because the ramifications I see is important. Everybody is in Facebook, in Twitter. They do all sorts of electronic transactions into Beam. So it is going to affect everybody. Now, how are we placed compared to global richer nations or other technologically advanced nations, the European nations, US, Australia? How are we? Where are we on this? If you can throw in a minute.
Right. So I think a good question. As far as the journey is concerned, I think we are late to the party, but it's a good thing as well. Because we have a lot of learnings from other jurisdictions which we can imbibe without making the mistakes ourselves. For example, when GDPR came into effect, we saw it did phenomenally well as far as personal data protection is concerned. But as far as innovation, entrepreneurship, and affinity towards the business side of things are concerned, it nosedived somehow. So therefore, our intent in India right now is to balance the two factors. Whilst personal data protection is very important, but we should also ensure that innovation, entrepreneurship, and business should not suffer. Okay, so that's been the thumb rule throughout in the new draft which came out and got passed. I guess we are in a good spot right now. We already had certain laws, for example, the Information Technology Act and rules. It's only that we are going to ramp up to a much higher stage. So I think education at every level is very important. That should be the most important thing at this juncture. Training and sensitization to the last person on the floor in your organization should be your motto at this time.
Elena Mahunta has actually two questions. So one, as part of business promotion or client engagement, we may share thought papers, product information, service capabilities. Do we need to seek consent even for sending out emailers?
Yes, so that's again a good question. Yes, you will have to seek consent because you are actually processing that individual's personal information, even if it is going to the person's personal email ID to of the organization, but you can identify the natural person. So yes, you'll have to seek consent. Yes.
Fair enough.
I just want to ask Supratim.
Yeah.
You know, when you send information, you know, about your business promotion, client engagement, you know, we talked about these thought papers, product information, so on. Where is the personal data in that?
The personal data is to the individual whose email ID you are using to send the email. You know,
Oh,
so
just
that guy. Yes, the guy can retaliate and say, listen, who told you to sort of use this personal information of mine and send that email to me? Did I give you consent for this? So, and you'll have to prove in a bad day that, you know, this is the evidence of that notice and consent being provided to you. Or you will have to use some of the other grounds which Smita was mentioning if you have some kind of a deemed consent from the person. For example, one line item, if you saw the first one, it said that if it can be expected that, yes, for that purpose, you will send a communication. A simple example which has been provided, which is that suppose you go to a medical shop and you say that, listen, you send this bill to me over my phone. I don't need a physical copy. And the guy takes your mobile phone number and sends you the bill. Now, that is without, that guy is not taking out a notice, then taking out a consent and taking consent from you. That is understandable. But if that guy then picks up that mobile phone number, sends it to the marketing guy and said, tomorrow onwards, whatever store offers are there, please start bombarding this person. That is not permissible. So this avenue of deemed consent of sorts, which is that legitimate purpose for which we have given the data transactionally to a person, is limited to that purpose only. So you gave the mobile number voluntarily, and that person gave you sent you the bill. That's it.
For example, if you look at hospitals today, they have a lot of, you know, personal data of patients and, you know, hell of a lot of information about their health and what all they've gone through, so on and so forth. Now that it becomes very critical in such organizations. Hospitals, I suppose, will be very critical environments.
Absolutely. Hospitals are, I think, is one of the high critical zone, like you're saying, because of the kind of data that they are handling, the volume of data, the time period for which they are keeping it, etc. And some of it is also used for research and development purposes. So you have to watch out for the anonymization standards which are used in order to, you know, do a research on the kind of patient data, etc. they have. Some of them have diversified into other things also, like pathological, you know, clinics or, you know, even medical shops, stores, etc. So the data today is spread all over. I think it has to be protected in a more robust manner as per the guidance under this law.
Yeah, a lot of work, and a lot of responsibility, accountability.
Yeah.
Thank you.
Smita, sorry, I think Smita wanted to add something. Please go ahead, Smita.
Yeah, the only thing I wanted to say was that, you know, there is some bit of, you know, leeway which is available to historically collected data. So privacy notices, etc., is something that will work over there. But the only thing is that we need to be clear about how exactly was the consent taken in the first place, and if we have the leeway to continue to use it in that fashion. Otherwise, the entire consent infrastructure is something that, you know, still needs to be evaluated.
Okay. Second question again is, what is your advice on handling the penalties imposed? And if cyber insurance is procured, which covers penalties, what is your view on it? I think it's too early, but yeah, I would wait for Supratim. Yeah, is there insurance available? Because the next question comes from an insurance intermediary.
No, the short answer is that we understand that there is no specific insurance yet. Of course, it's very nascent, very recent right now. It has come out. So, but what we are observing is a lot of insurance players are trying to now promote their cyber related insurance in a very comprehensive, in an aggressive manner. The reason is, if you look at the interplay, probably the data breach, data leak also will be a cyber incident in most of the cases. And therefore, if you're protected there, you could be having some insulation there. But mind you, that is only one part of this law. That is not the whole law. Okay. So yes, in case of data breach, data leak, maybe you will get some insulation if you have a proper cyber insurance. But otherwise, I think the insurance ecosystem has to mature to attend to this overall requirement of data protection, data privacy related laws.
So the next comes from an insurance intermediary. Samir Saxena. We should remind the customer to renew the policies well before the renewal date. For this, do we need to take consent?
No, so see, basically, if you see the initial consent taken, I think in all probability you will have a coverage of this aspect. If not, ideally you should create a your drafting in a manner that you have the consent. Of course, you can rely probably on that other ground that I spoke about, but better to have the consent drafted in a manner so that this covers the situation.
Again, the repetitive question again is, when you acquire or when you take over, should you have to take fresh consent? Yeah, it was clearly addressed that you need to go through every aspect of the acquired company and do that.
No, so I just one thing to add there, sir, that there's one leeway given, which is in relation to schemes of arrangement, etc., which has gone through, say, an NCLT process. There you get a rubber stamp, and then you need not go to the individuals, either whether it is employee data transfer or customer data transfer. But for all other purposes in commercial M&A, where you're not going to say an NCLT, then you will have to take the consent in the regular manner the way we discussed.
No, but I can understand Lalit's worries, but it's a legacy question. The act is just passed by Parliament and signed, and we are doing M&As in the next 2 months, and we cannot expect that we confirm the acquired company. The acquirer cannot expect the acquired company to have this. Maybe is it expected that you need to do a special due diligence on this aspect before you finally do the acquire?
Yeah, good question. I'll tell you. So this is a very interesting cusp. Okay, right now what you have to do is, when you are doing a due diligence as an acquirer, you definitely should check that the target entity has been fully compliant with the old law. Okay. Also, probably what you can take a look at is that how good is the system of this company to be compliant with an upcoming law of this nature. Okay, and then maybe you can decide on valuation or some additional stuff that you want to do. But you cannot expect that that entity will be compliant with the future law, of course. Okay. But the good background check that you can do is definitely do a check on the entire compliance till date as per the present law, the old law, future law, see how good they are to be sort of ramping up to a situation of DPDP Act.
How will this impact or modify educational institutions, schools and colleges from collecting children's data? You need to take the parents' consent?
Verifiable parental consent is very important. And I think schools and colleges these days have gone few notches up as compared to how we did our schooling. I was helping out one educational institution, and they said that we do biometric attendance for kids. We have their facial recognition to see where all they are moving around in the campus.
Oh,
These things are, can you imagine, like we have gone to a different level. So therefore, you have to take verifiable
my
parental consent for all of this. And these days, we are aware that, separations, etc. happen. So schools are skeptical. They want to take consent from both parents in order to avoid any kind of an issue in future.
So they may become a significant fiduciary with such biometrics with them.
Sir, when
Oh
we
my
were
God.
speaking, it is an eye opener for us also that some of these practices which are happening, probably parents are also not aware. Interestingly, there is no consent today with them.
It's very scary.
Very scary, sir.
Yeah, I know. We know has scared us now. But yes, I think it was nice. I think we're just running out of time. We're just a minute over. And I think I thank the audience for actively participating. Maybe we can directly mail in if you have queries either into me, BCIC, or with them. And would you be planning to share the presentation?
Yes, absolutely.
Okay. So we leave it with it. So if you people want, all the people who are joined, get the BCIC office to give you the copy of the presentation. Thank you. Shama Prasad, can you just take over? Or Vishwanath, see, you have anything to add before we close?
Sir, now
Mr.
shall we conclude? Yeah, please.
Yeah, Mr. Vishwanath wanted to add
No,
something.
nothing. I was just going to say that I'm so thankful to Prashant and Supratim and Smita for sort of taking us through briefly, of course, an oversight. It was an overview of the DPDP and lots to come, I'm sure, and a lot of things for us to learn and take care of. But this is just the beginning, and I think this is quite a very, very, very significant law that will impact all of us in business and enterprise. So thanks so much for making this happen today. And yeah, go ahead, Shyam. It's all yours.
And
Yes, sir.
and maybe Prashant and Supra and Smita and the Khaitan team, please keep your eyes and ears open for the next 3-4 months, and maybe are also framed. So then the whole prospect becomes a full circle, and then it can be more. Now, yes, you have made us aware of the pitfalls, and you have made us sufficiently to work on it. But then once the circle gets closed, maybe it would be a nice time to get back, Chairman Sab.
Yes, agreed. Absolutely, we must have another session
unanimous.
as things progress.
Yes, thank you, Shama. We go to BCIC for Shama Prasad to conclude.
Yes, sir. Thank you, sir. So I thank very much today's speakers, Mr. Supratim Chakraborty, partner Khaitan and Company, and Ms. Smita Jha, partner Khaitan and Company, for their very informative presentation on understanding the Digital Personal Data Protection Act 2023. I also thank all the participants and for their support and active participation. So we will organize many events from this committee in the coming days, and I request all the participants to fully support us. Thank you. Thanks a lot.
Thank you. Thank you so much.
Thank you, sir. Our
Thank you.
pleasure.
Thank you.
Thank
We'll
you.
sign off now. Have a good day.
You too. Thank you.
Thank you.